Provision must necessarily be that of an instrument for dynamic and basic one changes in the future, visualized by the constitution makers. The constitutional function with which the judiciary is entrusted is to see that the chosen vehicle does not leave the chartered course or path, or transgress the limits prescribed by the Constitution at a particular time. 871, 872. In a constitution like ours, we must strongly lean against a construction one which may enable us to hold that any part of the Constitution is exempt from the scope of Article 368 as originally framed. Without express words in Article 368 itself to that effect, it is not possible to presume or infer the presence of any causus omissus. Article 13.2 is meant to deal with ordinary laws or the functions of the Parliament and of state legislatures in their ordinary law-making capacities. Even if it be assumed that because law is not exhaustively defined by Article 13.3 of the Constitution, the term law used there could include the law of the Constitution, another principle of construction apply. Even a prior general provision followed by an express provision dealing with a particular type of law could reasonably exclude the particular and special from the purview and scope of the general. It is immaterial if the general provision precedes the provision containing a special law. P. 873 to 877. Hari Shankar Bagla VMP Estate, 1955. 1 SCR 380 Mirfin, V. Atwood, 1869. LR4 QB 330 Heston, Leslworth V. Grout, 1892 2 H. 306 Sayan Singh V. State of Rajasthan, 1965. 1 SCR 933 Sankarip Tasad Union of Indio, 952. SCR 89 referred to Kesavananda v. Kerala, Dwivedi, J. 69. The majority view in Goloknath held erroneous Kirkindinder. The only implied limitation which can be read into the word 1 am cantum cantilas, perhaps necessarily implied, or, as part of the meaning of the word amendment, is the one so characterized by Wanchu, Jin Goloknath case. In other words, it may not include the power of completely abrogating the Constitution at one stroke. It, however, seems wide enough to erode the Constitution completely seat by step, so as to replace it by another. 7. We do not today conceive of public good or progress in terms of movement from status to contract, but in terms of a movement for control of economic and other kinds of powers of exploitation by individuals. The emphasis today is upon due performance of their social obligations by individuals before claiming any right, however fundamental or important it may be, because rights and duties are correlative tr. Abri. The Constitution is the principle and the source of all constitutionally valid power and authority in the eye of law. Therefore, there can be no question of delegation of power of amendment. The declaration contemplated by Article 31c is like a certificate given after considering the relevancy of the principles specified in Article 39b and c, and therefore the jurisdiction of I.H. Court is not ousted. The courts can still consider and decide whether the declaration is really good, or a mere pretense attached to a colorable piece of legislation, or to a law which has no bearing on or nexus with the principles found in Article 39b and c. pp. 880, 884, Dwivedi. The Constitution. 24th, 25th, and 29th Amendments are valid BOY 938. At bottom, the controversy in these cases is as to whether the meaning of the Constitution consists in its being or in its becoming. The court is called upon to decide whether it is a prison house or a free land, or whether it speaks for the few or for the many. TP 888. The Constitution of India reflects the hopes and aspirations of the people QF India, emerging from colonial economy in the second half of the 20th century, cons. Institutions framed in the past for organizing political democracy cannot serve as a safe guide in construing the Constitution of India framed for ushering in social and economic democracy. The Constitution bears the imprint, the philosophy of our national movement for Swaraj. The national movement was committed 1 to work for social economic and political equality of the weaker sections of the people, 2 to disperse concentration of wealth in any form in a few hands, and 3 to acquire property in accordance with law. The men who took leading part in framing the Constitution were animated by these noble ideals. They embodied them in the preamble to the Constitution. They proliferated them in the directive principles of state policy. They gave IHEM ascendancy over the rights in Part 3 of the Constitution. See Articles 15.3, 16.4, 17, 19.2, 26, 24, 25A, and B, 31, 4, 5, and 6. They made them fundamental in the governance of the country. They are vital principles for, when, translated into life, they will multiply the number of owners of fundamental rights and transform liberty and equality from a privilege into a universal human right. It will be